Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Welcome to the latest edition of Angeion's Leading Litigator video series. Today is truly a special episode. We have the Executive Director of Public Justice, Paul Bland, on the show, who I've been dying to get on camera for a long time, and I think our viewers are really going to enjoy. Welcome to the show, Paul.
Thanks very much. I really appreciate the opportunity to be here. I appreciate you asking me.
Absolutely. So Paul, a lot of our viewers are already very familiar with yourself and your professional reputation and, of course, your organization. But for those who don't know you, who don't know public justice, who only know the name, can you kind of give us a background on all that?
Okay. So we're a public interest law firm and advocacy organization. We have a mission where we are fighting to protect the sustainability of the earth, to fight against predatory and abusive corporate and government conduct. We do civil rights cases, consumer cases, a lot of environmental work, a lot of work involving factory farms. When we principally litigate in court, we do a lot of appellate work, but we do a lot of cases in trial courts. Most of our cases are cases where we have a team, so we will go out and recruit some of the top trial lawyers in America who end up doing most of the discovery in cases, or frequently lawyers will come in and hire us into cases where we have particular expertise on issues. So we've had more success beating forced arbitration clauses by far than any other law firm or organization in the country. So people hire us, almost every month into some case where that's the principal issue in a case, or we have a lot of expertise in federal preemption or in court secrecy in a variety of different areas. So we usually get to work with people sort of collaborating as a team, and that lets us, it sounds like a Dilbert slogan of like low leverage, synergy, right, so forth. Right. But we actually do leverage our resources. We only have so many lawyers, and we're able to handle a lot more cases than you would think from the size of our organization.
Well, they say every cliche has, a scintilla of truth, or right. Would it be a cliche, right?
Right.
Paul, the mission is obviously outstanding. I'm curious why, for you personally, you decided to go the public interest route as opposed to remaining in sort of the private practice route and still being able to take similar types of cases. What attracted you to this life in this world?
Well, I really care about the type of cases I'm working on. I feel really drawn to cases where I feel like I'm fighting for the underdog, for somebody who's being bullied, for someone who's going to be voiceless. And when I was in the private sector, you handled the cases that were the cases most likely to make money. And in the nonprofit world, you have a lot more freedom to try and take cases where you really think you're going to be able to make an impact. But there are parts of our organization where you have people doing great discovery work and factual record work, but that hasn't been so much my path.
Understood. So for a long time, my main association with you was forced arbitration, and I think that a lot of people associate forced arbitration with you and your organization because of the work you've done in trying to defeat it. I was wondering if you could talk about why you find forced arbitration as a general matter to be reprehensible, is a similar word that you would use, and can you update our viewers where we are today? I mean, it's been a long road, and lots of important cases have come out, and you've been involved in many of them. But I think just a primer on where we were, where we are, and why it appeals to you to make this a cause.
Okay. So in forced arbitration clauses, corporations are sticking in the fine print these terms that say, if there's some sort of dispute, we've cheated you, we've broken the law, we've discriminated against you, whatever a corporation's done to break the law, that instead of going to court, you have to go to this form that they choose and that they set up. And because they're the ones who are writing the contracts, they tend to set up the form in a way that's rigged in their favor. And so there's two principal types of issues. One, there are a couple of things that are just inherent to forced arbitration that are problems. So the first is that the vast majority of forced arbitration clauses just ban class actions. They say that a consumer or worker cannot bring or be a part of a class action. And there are just a lot of cases in which it's not possible to litigate a case on an individual basis. There's cases where a corporation cheats 100,000 people, and if every single one of them has to go alone, then either zero of them or one or two or three people are going to go forward, but the vast majority of of the problem is going to remain unremedied. You're not going to be able to get the company to stop the illegal behavior. You're not going to be able to get any money back for people. A second thing is that forced arbitration is very secretive. It's not transparent in the way the courts are. And what that does is it lets corporations or bad actors do really terrible illegal things and get away with it. So, for example, there was this guy who was a CEO of a major fashion company who was serially not just molesting but frequently assaulting women who worked in the workforce. Then they would bring cases in arbitration, they would be paid off, it would be secretive, no one on the board knew. So this guy was able to essentially attack quite a few women before finally one of them went forward, despite the arbitration clause, went to court, risked all sorts of sanctions against her, but was able to call it to attention. So you see that all the time, that the arbitration clause are used to sort of sweep things under the rug. And then the last thing is that there's no serious judicial review of what an arbitrator does. So if an arbitrator has a completely crazy ruling, it will still be upheld in nearly all circumstances. And that's really a problem because it's unchecked power. Apart from the things that are sort of inherent to the nature of forced arbitration, the consumer and the employment setting, you see a lot of abuses. So there are companies who add in loser pays rules where it wouldn't be possible under the normal civil rights laws. So under Title VII, a decision going back to the early 1970s, Justice Thurgood Marshall had said, that a prevailing plaintiff, so if you're a worker and you bring a case, you say, I've been discriminated against. If you win your case, you're entitled to your attorney's fees. If you lose your case, you only have to pay your attorney's fees if your case had no substantial basis, if it was frivolous, something like that. Because otherwise people would be discouraged from ever bringing civil rights cases. Lots of forced arbitration clauses have just sort of these fee-shifting provisions struck in. Or forced arbitration clauses frequently make people travel long distances. Or they say that you can't get punitive damages even if the statute would let you have them, or on and on and on. So there are all these sort of bells and whistles.
So post-Concepcion,
yeah.
Where are we? I mean, if you don't follow this day in and day out, you're someone who doesn't normally sue. You normally sue over-the-counter sales companies, and you don't have this as an issue in your life, and you need to catch up right now. Where are we?
Before April of 2011, throughout most of the United States, the rule was that if a court would find that an arbitration clause that banned class actions was going to gut a consumer protection law or an employment law, the court could strike down the arbitration clause because it banned class actions.
Right.
Then in April of 2011, in this 5-4 decision authored by Justice Scalia, the Concepcion case, the Supreme Court essentially invented a new rule of federal law that overrode all these state laws that said an arbitration clause would be enforced even where it would gut and undermine an important consumer protection or employment law. It's probably the single worst case in the history of all consumer protection law. Seriously, right. Out of all U.S. Supreme Court cases, that one is the worst. And in the wake of that case, you can't challenge anything that's sort of one of the core elements of arbitration clauses. So the bans on class actions and so forth are things that are just off the table. So what's happened is companies have increasingly been writing clauses that harm consumers or employees in different ways, but they're getting them enforced most of the time anyhow. So because we've handled so many cases, so just yesterday we won a really nice case in the First Circuit involving truck drivers and how there's an exemption from the Federal Arbitration Act for truck drivers. And a couple of weeks ago we won a case against a payday lender. A couple of weeks before that we won a case against a debt buyer. So we've had a lot of success beating arbitration clauses. People approach us all the time and say, I've got this case, my client was completely harmed by grossly illegal corporate conduct, but the only thing that, but the problem is that there's an arbitration clause, so we'll look at those cases. I would say today that about 14 out of 15 times we can't find a way around that, and we have to say to somebody, look, we're sorry, but you're stuck. You have individual arbitration, there's nothing else. The 15th time we come up with something. And so we're better than anyone else in the country, in my view, at finding where are the seams, where are the places where you can help some minnow escape the net, right. Where the arbitration clause was drafted, the company was lazy, they didn't have good lawyers, they made some mistake, there's some technical problem, or there's one of the few exceptions to the act that apply. But it's really, it is extremely consequential to consumers and workers how forced arbitration plays out. It's just been incredibly unfair. There are tons of times where corporations break the law, really hurt people, and they just walk away. They get a clean bill of health because of the arbitration clause. So, we've been fighting them in court wherever we can. We've won a lot of cases over the last several years, but we won a lot of cases over about 18 years, and then the last couple of years we've been on a particular winning streak. We've been doing well in our case selection of the cases we're going after. But we're also doing a lot of advocacy outside of the courtroom. So I spent a lot of time working and trying to convince the Consumer Financial Protection Bureau to issue a rule that would ban arbitration clauses that won't allow people to bring class actions. Right. And they're still considering that rule, and it still could come out. We did a lot of work working with a lot of coalition partners around several other agencies adopted rules. So the agency that runs Medicare and Medicaid said that nursing homes can't have arbitration clauses and receive any kind of federal funding under Medicare or Medicaid. The Department of Education passed a rule that says the for-profit colleges that so often turn out to be scams can't have arbitration clauses that ban class actions. And so we've done a lot of advocacy around that. We've done a lot of advocacy in Congress. I've testified in Congress more than half a dozen times in both chambers, fighting against forced arbitration. And then we spent a lot of time just trying to convince and educate reporters around this. And I do think that you've seen this issue going from one that 10 years ago, if I said, I work on mandatory arbitration, almost anybody who was not a plaintiff's lawyer who I spoke to would say, what are you talking about? And now there's just been more and more publicity to this over time, where it'll come up in conversations or parties or something, you're out at dinner, and people are like, oh yeah, I've heard about that, that's this thing. And the understanding of what this is, the awareness of it has grown. It used to be you'd go on Capitol Hill and you could talk to senators, like when John Edwards was working on the Patient's Bill of Rights back in the early 2000s. This is John Edwards, been a trial lawyer. And they're passing this Patient's Bill of Rights, and we were like, Senator, you don't have anything in there about forced arbitration, it's gonna be a problem. He says, what are you talking about? He didn't know what it was. Today,
that's incomprehensible.
It's incomprehensible. I mean, today it is something that was part of this Democratic Party platform.
Right.
It's something that bill after bill has a provision about forced arbitration trying to exempt a bill, because most members of Congress understand if you're trying to deal with some problem, if you don't put in something that prevents there from being forced arbitration, you're not going to be able to solve it. So there's provisions about forced arbitration in Dodd-Frank and all sorts of different laws protecting service members and so forth. So we've changed the culture a lot over time. I mean, I think that right now we're a little bit in retreat. You see the new administration's walking away from some of the rules that were adopted late in the last administration. But I think in the long run, we're helping educate people in a way that this system that is so unfair is just not going to be sustainable forever.
Let me ask you a question.
Sure.
Everything you're saying is something that I've heard, I believe in personally. However, this is something that was enshrined into our federal law, arbitration via the FAA. There's a lot of people who argue vociferously against you about its benefits, expediency. Do you agree with them on any of the benefits? Is there a particular case, maybe commercial case, where arbitration does have advantages, or is it per se bad in your opinion?
Oh, there's no doubt that when you have arbitration between two commercially sophisticated parties in business-to-business setting, it can be a great thing. When you take out the power dynamic so that both parties are more or less on equal footing, then I think it's completely fair. I think in the unionized setting, it tends to work really well. I think where you have a problem is where you have something like a nursing home that's drafting a clause that has secrecy provisions and makes it really expensive, and they're picking the arbitrator and so forth, where they have an enormous, somebody who's really sick, they've just gotten out of a hospital or they've gotten a stroke. They're being sent to a nursing home. They're being forced to sign a bunch of papers in fine print. They can barely read them. They're on 6 medications. That person is really at a power imbalance. Sure. And what happens is you see some really ugly abuses in that kind of area, and it's deeply troubling. If Exxon wants to be involved in a case with Halliburton as a contractor and they want to have arbitration because they think it's faster, then fine with them. I think that's great. That's also what the act was really aimed at. If you go back and you look at the 1925 Act, what the act was about, it was particularly being pushed by the maritime industry, by the maritime sector, that shipping lines wanted to be able to, both the shippers and the carriers wanted to be able to have these agreements that they didn't want to end up in court court in some foreign country where they didn't trust that the courts of Brazil or Malaysia were going to be fair to them. It's essentially part of it where it really came from was sort of racism. They wanted to have a white businessman decide these decisions, right? So they passed this act which was really aimed at two commercially sophisticated parties. The idea that it would apply to consumers never struck anybody until the 1990s. And then in 1995, the Supreme Court suddenly said, oh, it applies to consumers. And it was really a shock to almost everybody. The idea that it would apply in employment outside of the collective bargaining area was something where the early court decisions had all said no, and it was really clear from the history. If you look at the legislative history of the act, it was never intended to do that. Former Justice Sandra Day O'Connor said that this act was an edifice of our own making. Basically, they made it all up. You know, the principal section of the act is this one sentence, section 2 of the act. This is one sentence that goes on and on. There's a bunch of punctuation. It's almost unreadable. And the Supreme Court has just invented rule after rule and this elaborate construction of law, all supposedly stemming from this one sentence. There's almost no language in the actual sentence that supports almost any of the rules that they've been doing. I mean, there's one dissent where Justice Stevens said that it was like a big collection of Russian dolls, that there was just this thing that they'd made up that made no sense. And so I think that one of the things that's frustrating to me is, you know, when you see people defend this, say, oh, well, Congress made this decision. So, you know, Justice Gorsuch in his confirmation hearings draws some questions from Senator Franken. Well, isn't this really unfair? And he's like, oh, well, you know, the Supreme Court's just been following what Congress meant back in 1925. You know, the history is that's bad history. That's not true. This is not what Congress intended in 1925.
So, continuing sort of on the theme of power imbalance, HR 985 is upon us. It's passed the House. It's in the Senate. What do you predict? And I know that in this political climate, it's very difficult to predict anything, but you're pretty close to the ground on this issue. And maybe before you even answer, you could tell our viewers a little bit what HR 985 is if they're not familiar with it, and where we go from here as it relates to that bill.
So actually, we're just coming up now on the 50th anniversary of Rule 23, the class action rule, the Federal Rules of Civil Procedure. And for the last 50 years, courts have been trying to figure out about what does the language of that rule mean? You know, when is a class action superior to other methods of litigating? When do common issues predominate over individual issues and so forth? And there's been this series of court decisions slowly, carefully working this out. And most of the leading decisions actually written by late Justice Scalia or Chief Justice Roberts. Now, all of a sudden, Congressman Bob Goodlatte comes forward with this bill, HR 985, which has all these provisions, and he doesn't even hold a hearing on it. They introduced the bill on like a Thursday, so we first see the text, and then they mark it up and they rush it through the committee the following Tuesday. Then within a couple of weeks, it's in front of the entire House of Representatives, still no hearing, no discussion of what it means, and then they rush it through the House with one set of amendments in the morning, then they withdraw those amendments, they have another set of amendments, which most people haven't even read, late in the afternoon. Just yesterday, I did a debate against a leading spokesperson for the Chamber of Commerce where he completely misdescribed what the amendments were that were passed just before the bill passed. A couple of weeks ago, I debated a guy, a different surrogate for the Chamber of Commerce, who completely misdescribed what the entire bill did in a way that was so inaccurate that there's really this thing that's sort of a black box to a lot of people. But the upshot of it is that the bill would eliminate about 95% of class actions. It is really an extreme bill. There's a lot of different provisions, and rather sort of walking through all of it, let me just give you a couple of examples. Okay. So the first is that the bill says that people have to have, everyone in the class has to have damages of the same scope and type as everyone else in the class. So type of damages talks about the nature of damages, like what types of damages are you talking about. Scope's talking about how big they are. So think about that if you apply it, for example, to a securities fraud case. So say I buy a stock, and so given my amount, my income, I buy 100 shares. Angion's really successful. So you have 10,000 shares of stock, okay? Say it's Enron, complete scam. People are totally cheated, all right? And there's a terrible securities fraud. We both want to be part of a securities fraud class action. Do we have damages of the same scope if I only have 100 shares and you have 10,000 shares? We don't have damages of the same scope. Your damages are way higher than ours. So you're saying you can't have a securities fraud case involving Enron? Well, that's true of most class actions, that you would be able to say that the damages vary in size. In an employment setting, you could have a workforce in which women are all paid substantially less than men for the same sort of work, but if they don't all have the exact same salary, their damages are a different scope. Similarly, the bill says that absolutely every member of the class has to have been damaged in that way. And that's sort of a crazy idea. I mean, right now, if you have an antitrust case, can you imagine a defendant coming into court in an antitrust case and saying, hey, Your Honor, we've got proof that 10% of the people in this class were not affected by our cartel behavior. We only cheated 90% of the people in the class. That would not stop any federal court in America from certifying that case as a class action, right? So this idea that every single member of the class, so you could have a consumer deception case and they come in and say, oh, this one consumer actually figured it out. Or this is a securities fraud case. They find one consumer, or they find one stock purchaser, one investor who knew that the FDA trials were going to go the different way than what the company was publicly saying, right. You know, that kind of thing. So the bill is really intended to completely wipe away class actions. So now it's in the Senate. I would think that the Senate wouldn't be inclined to go forward on this. I mean, I think first of all, you have a lot of senators who are very concerned about pay equity issues, and the fact that this would eliminate the ability of women who are paid less than men for the same job, you would hope would be something very influential to them. There have been a lot of cases involving members of the armed services. So for example, sure. There was a case where a bunch of pilots who worked for United Airlines were drawn into the Army Reserve or Air Force Reserve, and they went to the fight in the Iraq War. They came back and United basically stripped them of nearly all of their pensions. Well, that's illegal. There's a federal law that says you're not supposed to do that. So there's a class action, everybody got 100 cents of their pension dollars returned to them. Are there really going to be senators who are going to vote with, you know, the Chamber of Commerce and large corporations against members of the armed services? There's a series of issues like this. One of the things that's interesting about this is, you know, so many senators ran for election on this sort of nationalism, America First platform. Well, a lot of class actions involve foreign corporations that are cheating Americans. So for example, you look at the Chinese drywall cases. So here's this drywall that comes from China that turned out to have all these problems. So you get this installed in your house and it's off-gassing various toxic gases. It's making it impossible to live in your house. So there's several class actions that got 100 cents on the dollar for people who had this problem. They come in, they fix your house, someone actually tears out the bad drywall, they put in new drywall, they fix it, you get a refund on your money. You know, it's a completely successful class action before anyone gets any attorney's fees. And so now you're going to have a bunch of senators who are going to be running for re-election where they're going to say, oh no, we really want companies from China to be able to screw over American homeowners. And we want each American homeowner to separately, individually have to go find the company in China and come in with experts to prove that their house was suffering from this sort of problem and so forth. I mean, how is that an American first attitude? So on many levels, I would like to think that this bill wouldn't get through the Senate. Having said that, you know, I live in Washington. I read about 8 newspapers or blogs a day. I hang out with political people a lot. And I will say that I do not know anybody in this city who has accurately predicted more than like 50% of what's happened in the last year. I mean, the conventional wisdom was that Hillary Clinton was going to be president. The conventional wisdom was the Democrats were going to take the Senate. The conventional wisdom was it wasn't going to be possible to repeal the Affordable Care Act, and on and on and on. So I think that for me to sit here now, I mean, humility is not one of my great strong suits, right. But if I were to sit here now and tell you what's going to happen in the US Senate in the next 6 months on anything, then I think I should just be fired, because I just think it's like nobody knows. And the people who are confidently predicting, oh, this will never get through the Senate, it's like, hey, you know, where have you been the last year? I mean, how many things were you also certain about last year?
Sure.
I mean, I was pretty sure the Wizards were going to beat Boston last night. That didn't work out, so.
Paul, listen, this has been fantastic. I always enjoy hearing you speak, and especially on these issues that are so clearly near and dear to your heart, near and dear to a lot of our viewers' hearts. So thank you for joining us.
I really appreciate it. It's really fun. Thanks.